he was looking at some serious time. He was looking at like 65 years to life. And he got acquitted of the attempted murder and the assault with a deadly weapon against a peace officer. He was found guilty of a misdemeanor of negligent discharge of a firearm because the jurors believed when he shot at my back as I ran away, he wasn't shooting at me. He was just shooting the gun.
This goes to the trial. This goes to, I want to really focus on this because what happened in this trial and the tactics used in this trial and legislation that impact this trial is really indicative of, in my opinion, the hatred of law enforcement and the lies, the absolute lies told about law enforcement and how it is ruining society. It is disintegrating society. And people are not looking for the truth anymore. I didn't know about the bill, let alone the law. It's California Assembly Bill 3070 that you reference in this article. And it prohibits the unfair, I'm going to put some quote, unfair exclusion of potential jurors. And this law went into effect in 2022 before your trial. So it was certainly, it played. I'll let you talk about 3070. I actually printed out some articles and the actual legislation itself, and I'll get deeper into the weeds about it. But I want you to talk about, from in your own words, what 3070 is.
Yeah, so Assembly Bill 3070 was drafted by Shirley Webster. She's a Democrat from San Jose. And this
Wait a
bill,
minute. I got to interrupt. A Democrat?
yeah,
Actually,
shocking.
I'm shocked. I almost fell
I
out of my
know.
chair, but go ahead.
I know. I could not believe it. But so 3070 was amended and retried basically after the Minneapolis effect of 2020. They wanted this bill passed so bad because they thought that there was not jury inclusiveness in criminal cases. So I think 3070 was well intended. However, it was not well thought out. The aftermath was not well thought out, and the populations that it would affect was not well thought out. So what 3070 did is during the course of jury trial, the prosecution and the defense attorney both get a certain number of preemptory challenges, which means if you have a juror sitting there and they say, I hate females and I hate this and I hate that, and it falls into a gender, religion, ethnicity, they're immediately excluded because they have bias. They're not fair, right? 6th and 14th Amendment right to a fair trial. Well, what 3070 did is they took away law enforcement. So prior to this, law enforcement was a protected class. If you said, I hate cops, they're all bad, you would be excluded because, they're protected. 3070 took that away. So now cops are no longer protected. 3070 also said that if you have a juror that falls asleep or gives unintelligent or confused answers, you're no longer allowed to intervene. You're not allowed to wake up this juror who is going to be making a verdict on your client's behalf. It's just a mess. So the way that 3070 impacted my case was 5 out of 12 jurors, after the verdict was read, were found to have implicit bias towards cops and myself, obviously being the occupation of a law enforcement officer. They said, all cops are bad, all cops are racist, all cops fall into this stereotypical category. We think he was in self-defense. The criminal is, off the hook. She's the problem. She should have expected to be killed because she signed up to do this job. They had no understanding of my testimony. Like I said, I was cross-examined by the defense attorney for 3 days, and I would look over and speak to the jurors as we are instructed to do. And a few of them would be sleeping. A few of them would be doodling. A few of them would be looking into space, not even listening to my testimony. And it was one of those things where from day one, I knew that we had just lost. I could see it on their faces. I felt it. I had a full-blown panic attack after reading my homicide report, going into the details, and the jurors were rolling their eyes at me, shaking their head. They thought that I was not credible and I exaggerated everything.
You're telling me that these people were actually interviewed by the prosecutor, I believe, right? And they actually admitted that they had bias against law enforcement. I want to make sure, is that right?
Yeah, that's right. She talked to the jury foreman afterwards and said, basically, how did you guys come to this decision? How did you come to this acquittal? I don't understand what went wrong. And the jury foreperson said, basically, like, they hate cops and you guys allowed them to. There was actually an alternate that was seated that basically waved the flag and said, do not pick me. I do not like cops. They're all bad. I've had bad interactions. Don't pick me. Well, she was selected anyways, and then a juror had to be excused. So she sat on the seat of the 12 jurors. So, you know, Do I think that there was a little bit more that maybe the prosecuting attorney could have done to
Mhm.
remove this person for other means? Maybe so. I wasn't there. I'm not in the legal profession. But, if you have somebody basically saying up front that they're not going to be able to give a fair trial, then where's my constitutional protection?
Well, it's down the toilet, and that's
Yeah,
exactly what happened. But the point I wanted to make was implicit bias is the claim is, well, you're going to act subconsciously, even if you don't mean to. You're going to treat people differently. But you're telling me at least one of these jurors said to the prosecutor ahead of time, "I don't like cops," before the trial started. Of course, the
right.
trial starts when they're selecting jurors, but before testimony started, this person said they don't like cops. Is that correct?
That's correct. That's what I was told.
Well, that is not implicit bias. That is an explicit bias. That is consciously saying, I have a prejudice. I have a bias against this person or this group of people. That's explicit bias. That's like Ku Klux Klan bias. That's what that is. That's saying, I don't like this person or I hate these people because of XYZ as a group. Now, I want to juxtapose that. I wonder if the defense attorney under, I don't think so, under AB 3070, I wonder if the defense attorney would allow 12 or say 14 jurors with alternates to be seated who are all married to law enforcement officials. I wonder if that would happen.
Yeah,
I'm guessing not. I'm
yeah,
guessing not. But someone who says they hate cops, that's okay. And this is what you
right.
dealt with in the trial.
Yeah, I mean, it was a little not a little, it was very heartbreaking to know that I basically begged the district attorney's office, like, I cannot testify. I just spent nearly 4 years trying to retrain my brain to not be impacted by this. I cannot go on this stand. And for this to be the outcome, I don't think anybody obviously expected. But for this to play such an integral role into the acquittal on the basis that, these people, these jurors excused criminal behavior caught on camera with eyewitnesses, with an admission and a confession by the suspect. That stuff was omitted by the judge, which we can get into later. But,
Mhm.
they're letting dangerous criminals out into their community because they think they are doing the world a justice by not giving law enforcement being able to be victims, when all they're doing is they're re-victimizing themselves, because now you have a criminal who admitted to the crime. He said he would do it again. He said he doesn't care about what he did, but now you just let them go free. So then when he commits another crime, hopefully not against, the neighbor or a family member, what do we expect? Why do we think crime is so bad right now?
That's what it is. It's ideology that we're going
Exactly.
to even the score for previous evils committed in this country, which we all agree that horrible things have happened, inexcusable things have happened in this country. But here's how we're going to fix it: we're going to even the score.
Mhm.
We're not going to prosecute criminals because they look like me, they're part of my group, and things like this. Rather than being objective and say, listen, if you did the crime, you got to do the time. Obviously, it's a cliche, but it's so true. Um, it's absolutely a shame, but again, California it's a petri dish of this. It's not only California, but I say so often, California being the largest state in the union and so impactful, politically, culturally, economically, that as California goes, many other states follow, and that's not a good trend right now. I wanna talk, you mentioned, you actually brought it up. I wanna talk about, if you have some information about the judge and what the judge did and some of the things the judge did in this trial that impacted it, that's fine. Before we move on to the bill here specifically, I wanna be clear on the charges. He was charged with attempted murder, is that correct?
Correct.
Assault on a peace officer, is that correct?
Yep.
And, of course, I forget what felonious discharge of a firearm or negligent discharge of a firearm. Is that, were there any more than those 3 charges?
Yeah, so he was charged with battery on a peace officer. He
Battery.
and then he had the obstructing resisting, which, 148 is a solid
Mhm.
misdemeanor. And he had the removal of a peace officer's firearm. And
Right.
on top of all those, he had, enhancements of GBI and a few other gun related things. So he was looking at some serious time. He was looking at like 65 years to life. And He got acquitted of the attempted murder and the assault with a deadly weapon against a peace officer. He was found guilty of a misdemeanor of negligent discharge of a firearm because the jurors believed when he shot at my back as I ran away, he wasn't shooting at me. He was just shooting the gun. And the jury hung on battery, removal of a firearm, and obstructing resisting. They could not determine.
Well, I watched the Despicable Defense Lawyer. I watched a couple of interviews with him talking about, well, he was firing one way and the deputy was running a different. I don't know how these people sleep at night. I guess if I were charged with an absolute despicable evil crime, like this guy was, or if I were O.J. Simpson in 1994, I'd go out and hire the slimiest, most persuasive, despicable people as well that I could afford to get off. Because first of all, if I'd already committed murder, I don't really have any compunction about
Right.
hiring bad people to defend me, right?
Right.
So I guess that in the scheme of things, and I'm certainly for a system where we have defense attorneys. There's no doubt about that. But I literally do not know how many of them sleep at night knowing the people that they put back on the street. And that goes from my time in being in court on, in felony prelims and felony trials, misdemeanors with DUIs. I'm thinking, what is this jury thinking? What more do they need? And then back then, of course, 20 years ago, 25 years ago, when I was sitting in the stand, I would say, my God, if we only had video of this crime, they'd get it. Well, they had video of yours, and they still walked away and left this criminal back on the street with time served. So he actually never served a day, if I'm correct, for the discharge of the weapon, even let alone anything else.
No.
So you alluded to the fact that the judge was obviously a part of this malfeasance. Were there some of the things that you can recall now the judge did that ended up getting this guy back on the street?
Yeah, so I am still in the process of getting my transcript so I can see all the motions that were heard and filed and all of the objections and everything that was raised because, we have a problem here, but based on what I was told from the people that were in the courtroom and my deputy district attorney was the judge is married to a lieutenant who works for a neighboring police department. I was told that she is very fair and impartial and she's a great courtroom to be heard in. Well, from the get-go, she refused to allow the suspect's testimony to be heard in court. Mind you, this suspect was interviewed two separate times. Once was, I don't remember the exact time frame, but it was enough time allowed, I want to say 18, 24 hours after he had surgery and after he had anesthesia. He waived his Fifth Amendment rights. He wanted to speak. He gave more details about trying to kill me than I gave to homicide at the time. He said he wanted to kill a police officer. No female tells him what to do. He talked about how he put the gun to my head to try and end the violence, all of these horrendous things. The judge said on her own accord that she believed he was under the influence of anesthesia and the statements would not be heard. Throughout both statements, because homicide went back the next morning and got another statement, refused to let the jury hear it. So obviously very damning evidence. If somebody is admitting and confessing to a crime, it should be heard. It's evidence. And, a failure of the district attorney's part is they never brought in any experts. No experts were heard on my case, no anesthesiologists, no firearms experts, no use of force experts, no, malfunction experts, whatever you want to call it. Nobody was heard besides me and my two partners. So this judge was able to make this ruling and we didn't stand up and call in an anesthesiologist and say, wait, hold on. We allow suspects who are under the influence of, drugs and alcohol, their statements are allowed in court, but anesthesia, like there's no ruling on that. So you can look it up. There's no judgment that says it has to be X amount of time after. That does not exist. The judge made it up and ruled that in. So that was not heard. There was a piece of gun evidence. I can't tell you exactly what it was. It was basically a firearms report that she would not allow in because in April of last year, Russia hacked the sheriff's department. And what they did is they corrupted a lot of the files. And some of my case was involved in that, where they are still trying to get it back. And the judge was angry that this hacking did not allow a piece of evidence to enter in. So she excluded it and told the prosecuting attorney to ask me if I would take a deal for, I think, like 4 years or something. But nobody would give me any indication on what was going on, what was happening. It was like secret squirrel the whole time. As a victim of a crime, I think I deserve to know what's happening for my case for you to all of a sudden be asking me if I would take a deal. So I said no. And that was the last I heard. So, like I said, I'm still waiting. Transcripts are about $11,000. They're very expensive. So I'm still trying to figure out what really went wrong, but that's what I was told.